Hi, everyone. Welcome to episode 83 of the Immigration Lawyers Podcast. In this episode, I'm going to have a legal review with a past guest, Canadian immigration attorney Laurie Tannous, about the details of Canada's immigration laws, the so-called points system, as well as how they handle various issues like waivers and DUI inadmissibility. As always, you can access more interviews and information about the practice of immigration law at www.immigrationlawyerstoolbox.com. Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted, and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. So, Laurie, thank you so much for coming on the show. I was looking forward to talking with you again. We had a podcast, it seems, literally years ago, episode 12 of the Immigration Lawyers Podcast, and we talked about your background, but I'm glad we could go back into another discussion today and discuss the details of Canada's immigration programs.
Thank you for having me today, John.
Thank you. That was a fast start to conversation. But one of the main reasons I was interested in doing this podcast is because you hear a lot about Canada's points program, and it's so foreign to the way we do benefits, immigration benefits here in the U.S. And so I thought it's really important for Americans to know about this, American immigration lawyers. One is from the perspective of, if there's going to be reformation of the immigration system in the U.S., we got to understand how other people are doing it, and then see how those results are and how it works with their culture and everything. And then secondly, probably more importantly for our daily practice is so many times our clients want to visit Canada but may have issues. For example, we may have a DUI and that creates issues there. We might have travel ban clients who could potentially overcome the travel ban by becoming landed lawful permanent residents of Canada, and all of these kind of issues. So I wanted to discuss that, but really just start on an overall big picture and then move down. So if you could you give us an initial synopsis of what the point system for Canada is?
Certainly, yeah. So, I think I mentioned this to you in one of our recent conversations that the fact that the U.S. is now looking at this point system is interesting because for as long as I've been an immigration lawyer in Canada, that's the way we've done things here. So we're very accustomed to that model, and it works. It's got some flaws, but it does work. And so essentially, some of the criteria that is looked at to determine whether or not somebody would be a viable candidate for permanent residency into Canada is their language, so their ability to speak English and or French. French is our second official language here. So in terms of the points, so a person would need a minimum of 67 points out of 100. So that's the minimum they would need to even be able to submit what we call a profile for express entry. And I'll talk about that in a minute. But in terms of their criteria or how they are able to collect those points, so language is one, work experience is another. They certainly get extra points if they have any previous work experience in Canada. So a minimum of 1 year work experience in Canada boosts them up more than just having work experience in their home country or anywhere else abroad. Their education, so in terms of their degrees and their certifications, their age. So we do look at somebody's age and what their ability is to contribute back into the country. Another big one is the arranged work in Canada. So I always encourage people that if they are interested to try and make connections with companies here and to try and apply for jobs here, because if they are able to have an actual employment offer, it's almost a guaranteed ability to come and work here and then eventually become a permanent resident if all things go well. And that is hard to do if you're not from here and you don't have something lined up, but it definitely happens all the time. So it's just a matter of looking for that. And then the other one that's looked at in terms of gaining points is adaptability. What they mean by that is do you have an aunt or an uncle, a sister, a brother, a parent, a child already here in Canada? So therefore, the likelihood that you'll be able to adapt to the country will be that much better because you've got some roots already planted here. So that's the overall structure in terms of what we look for and how people can gain those 67 points, a minimum. From there, you're able to then submit a profile for express entry. And what that is that's just an automated system that we use that collects the applications. So instead of using a courier and sending it in, it goes into this portal. And then within that portal, a number of things are looked at, but the minimum score in that portal as of today, because I just checked it, was 457. So if you've got a minimum of 457 points within the express entry profile, you will likely be able to be invited to then apply for permanent residency as a skilled worker.
I'm kind of confused. So you said there was a 67 minimum out of 100, and then
it's 2 stages.
Oh, okay.
Yeah, it's in 2 stages. So to be able to even put your profile together and put it into the express entry, you have to have those minimum, right? Mm-hmm. And so meaning if you've got somebody who has no work experience, and maybe some language ability, they've got a degree, they're a little bit older, they're likely not going to meet that 67 out of 100. Okay, so they're not even going to be able to put their entry into the express entry system. So you need to meet that. All that does is it says, okay, you've met our minimum cutoff. Now you go into the pool, and in this pool there are all these other thousands of candidates who you're sort of competing against to see who has better profile, right? Mm-hmm. So my test on my English score, did I get all 7s? If I got all 7s, but somebody else got only 6s and everything else is identical, it's going to bump that 457 up. And so it's tabulated in a different way, but it's essentially meaning the same thing. Like it's looking at those same criteria that I just discussed.
Now, which English test do they use to test language ability?
We have a couple of different ones. The IELTS is one that is used, mm-hmm. and then and both of those, I'm trying to think.
I know they have those in the U.S. too. Yeah, for
alphabet.
Yeah, exactly. For colleges, they always have those. Yeah.
Yeah, and so with both of those English tests, you can do them. There are many places where you're able to do them. CELPIP. So CELPIP is the one, and then the IELTS is the other. So those are the 2 that we commonly, have people take.
And what about age? What age is better or worse? What age range for this process?
Yeah, I mean, and so it's tricky, right? Because if you've got somebody that's in their early 20s, they're not going to have, a real robust work experience or, fully credentialed, degreed person. Mm-hmm. Whereas if you've got somebody in their late 50s, they're going to say, okay, well, they're a little bit on the, in the other side of the, that spectrum, and what are the likelihood of how many more years are we going to be able to get out of them in terms of being able to work here, mm-hmm. and could there be health issues? So I generally say that if, you're anywhere between 25 and 50, early 50s, I think that's really a good age to say, you'll get some good points in that area.
And then for having relatives in the U.S., I discussed, aunts, uncles, brothers and sisters, children, parents, and grandparents are part of that too? Would that be a benefit if you have grandparents?
A grandparent would be better than, let's say, a first cousin, but a parent or a sister or brother or an aunt and uncle are better than a grandparent,
would
right?
You...
So closer.
Sure. Would you tell them, like, if you had cousins and one grandparent, would you just include that anyways to try to get some points, or how does that? Is that an exact measure or the overall picture kind of thing?
No, it's an overall. So when they're looking at your adaptability, if you say, I have a relative in Canada, and they also look at what province they're in, right? So if you're saying I want to come to Ontario, which is the province that I'm in, but you've got a relative in British Columbia, that's not as good. But if you've got, an aunt that's in Toronto, that's going to be better for your overall adaptability.
It's just funny. That's why we need lawyers. It's always little nuances and this and that. That's why we need lawyers,
always.
I guess, help people through this.
That's it, because there's never black and white, for sure.
And you brought up the provincial issue. And so how do the provinces get involved in immigration benefits in Canada?
In recent years, they've said, look, if we need more people. So in some areas, they're more rural, or some provinces, we don't have as many people that tend to immigrate there. So what they've started is this Provincial Nominee program. And so as I explained to you within that express entry profile, you put your portal, you put your profile in there, and you wait. Now, sometimes you can be in there 6 months in that profile, waiting in the portal, and you'll get a letter of invitation from a province saying, hey, you've got some skills. So if I've got a doctor, let's say, and they say, oh, you've got some skills. Are you willing to come to this area in Ontario because we're in need of your expertise or some of your skill set? And what will happen is once you get that invitation, it's a whole separate, application process. You get taken out of that pool. But what it does is it allows you to apply sooner than having to wait along with everyone else. And so the one in, Ontario, for example, one could be based on, the need, the human capital. One is if you've got a job offer by somebody. So in that case where, you could be matched with somebody who's in need of your skill set.
I see. And what if like someone comes in with a job lined up and they get, status and they're in Canada, and then soon after they get in a fight with their boss and they quit and just do something completely different? Is that frowned upon, or does that become an issue later, for example, when they're becoming a citizen?
Yeah, so as long as, and they can change their employer, so there's just an application to extend or amend or change your employer. And so, especially if you're in that initial phase where you have not gotten, you've not become a permanent resident yet, but you're still waiting. So you would just change your employer in that case. If you're already a permanent resident and any conditions that were there have been lifted, then it's not an issue. Now, if they see that there's a tendency with one employer, for example, that provides a lot of these arranged employment offers, and people come in and then there's a high turnaround, that's going to be a red flag for IRCC, where they're going to say something's funny here, right? So they'll definitely keep an eye on those kinds of things from an employer compliance perspective.
So, in the U.S., we have the green card program, which could take at least like 2 years before people could get the green card. If they're able to get a non-immigrant visa to come, like H-1B, to come here temporarily, they could work and wait till the green card becomes current and all that kind of stuff. In Canada, do you have to enter with a non-immigrant work visa first and then work your way up, or could you straight up come and get the work visa without being in Canada previously, or both ways possible?
Yeah, both ways are possible. So, I often have clients who get a job offer. They need to come straight away. On the top of their mind is not necessarily becoming a permanent resident, but they say, hey, I might do that, in a few months from now. I want to come, I want to feel it out, and I want my work visa. So we either prepare their work visa application online or at the border or at a consulate abroad. So they maybe hadn't even stepped foot into Canada yet until they obtain that work permit. They then can come in that way and then apply for permanent residency. Or a situation where somebody has come in, they don't have an arranged job offer, so therefore they're not going to have a work visa, but we have them in the skilled worker stream, and in 2 to 3 years we finalize their application, and they'll get the green card, essentially that permanent resident card, right away, and they'll never have worked a day in Canada, and so they'll come right with that card in their hand.
I see. And how strict are they with regards to unskilled labor? If someone wants to bring, unskilled labor to Canada, do they just get less points on the total list? But if they could overcome it with additional points through family members and stuff, or is it just unskilled labor frowned upon?
Yeah. So no, we've got, I work with a number of companies who are in the trades, so machinists, tool and die, CNC, welders, those types of things. And because there's such an extreme shortage for the trades in Canada, we are able to apply for them the same way that I just explained. So they're not perhaps a skilled worker in the sense of, an accountant or an attorney or that kind of profession, but they're a federal skilled trade worker. So therefore they've got that trade. And as long as we can demonstrate that there is a shortage, then they go through the same type of stream that the others would go in. It's just they then look at things like, okay, explain to me why there's a shortage in your area, making sure that you're paying fair market value. So those types of things are looked at when we're talking about the trades.
Okay. And, kind of employment-based, but what about the investor program? Canada had one, but it seems like right now they're not doing it anymore.
No, they closed it, and not only did they close it, but just recently there had still been one open that was in Quebec,
Hmm.
in the province of Quebec, and they just shut that one down as well. They canceled the entire program. They're actually refunding people
Wow.
their application fees. Yeah, so because there was such a backlog, and so this was back. They actually passed a bill back in 2014. To say that, hey, because of this backlog, we are no longer going to accept any more applications for the immigrant investor program. It's unfortunate because I think there are a lot of people who had much interest in coming in and had the funds and the wherewithal to invest in and have a business that could thrive here.
Yeah. Now, really quick, going for just one more note about family-based. Canada's a little different because it allows grandparents to get status based on a grandchild relationship. Is that correct, or am I
Yeah.
off?
Yes.
Oh,
Yeah.
that's
No.
amazing.
No. That is correct. Again. Yeah. It is. And so, but again, you've got to have all of the proof that you know what I'm saying that
Yeah.
that the lineage is there and so forth.
Okay. Well, hopefully I'll be there. If you can trace the birth certificates and all that kind of stuff. But as
Yeah.
immigration lawyers, we always see
Exactly.
stuff where it's not there, or birthdays are wrong, or the name of the wrong parent is on the birth
Right.
certificate.
That's what I mean. It's like, okay, really, that's your grandparent? Like, come on, right? So sometimes it gets a bit tricky depending on the source country that we're getting it from. But if everything's in order and you can demonstrate it, then yeah, it is something that we've got that you guys don't have in the U.S.
Okay, so going back to business now, do you have an L1 equivalent where like a foreign company is transferring a CEO to come to the affiliate or subsidiary in Canada? Do you have transnational company kind of visas?
Yes, it is the exact same thing that you guys have. We don't call it an L1, we just call it an intra-company transferee application, and
Hmm.
the requirements are identical, meaning you've got to be able to show the intra-company corporate relationship, you've got to show that the company, you've been working for a year out of the last 3 years at that company in the United States, and that when you're coming over to Canada, that you're going to be, so if you say you're coming over and you're going to be director of sales, all right, what are your duties going to be? Who's going to be reporting to you? So it gets very,
That
very
nightmare,
specific
yeah.
the same way. Oh
I-
yeah, you know what I'm talking about.
So, I was looking over some stuff about Canada. So, on the business side, they have a corporate stream and entrepreneur stream. Is that correct? Are those still there, or could you expand on what those mean?
No. Yeah, so the entrepreneur also was shut down. So outside of the investor one, the entrepreneur was also canceled. So that no longer exists. There is something it's called a startup visa, and so if you have an angel investor or let's say a capital fund, an equities fund that is in Canada and there's a number of requirements that if you can meet those, you may be able to get a startup visa
Hmm.
for your company. But it's a very limited. So I wouldn't say that it's a program that's as open as the investor one used to be or even the entrepreneurial one used to be.
Yeah, I mean, President Obama tried to do probably that's where they got the idea, but tried to do a similar thing here, but President Trump shut that down as soon as he got in.
Right.
With regards to
Yeah.
L1, the intercompany transfer that you guys have, could the foreign company just straight up purchase a company in Canada and then just transfer them over? Are there restrictions as to how long
Yeah.
they have to have owned the company or anything like that?
Yeah, no, the ownership not necessarily as long as you can, you've got that minimum 1 year, right? So one full-time year within the last 3 years.
Hmm.
So, but if let's say there's a U.S. company that says, hey, I want a facility in Toronto, they buy it, and then they've got employees that have been working for them in Canada, or sorry, in the United States for the year at that U.S. plant, not an issue as long as you can demonstrate that the ownership is there, sort of the day after the application was made.
Hmm. Now, speaking of U.S. visa laws in Canada, there's obviously the treaty that's known as the NAFTA treaty that President Obama tried to redo. I think they changed the name of it or something like that. But essentially, they kept it the same on our end. I'm assuming they did for you guys too.
Yeah,
Have you been
yeah.
processing
And
TNs normally again, or still have, I guess?
I do. Yeah, we still have. There hasn't been any disruption in that sense. And I mean, on one hand, we were hoping that we were going to see an expansion of that list of
Yeah.
professions within the NAFTA. The now you guys call it USMCA, we call it CUSMA. We were hoping that there was going to be a longer list or a more expansive list. There is not. However, the other flip side of that is that no harm was done, meaning nothing was taken off of the list. And, we're still able to process those TN visas without interruption, right at the border or online as well.
In Canada, border officers have the same kind of hesitation, or at least same review of when it comes to the management consulting category of TNs. Is that correct? It requires additional attention.
John, you just gave me heartburn. You just gave me heartburn. We're not supposed to talk about management consultant visas. No, yeah, it's the same troublesome. There's that threshold, that difficulty, because unfortunately, it is an area that tends to be abused a lot.
Mm-hmm.
Everybody's a management consultant, and so. I just had one approved a couple of weeks back, and so as long as you can show, as long as you can show that person has the qualifications and they genuinely are a manager and they genuinely are coming over to do those types of activities, I think that there's a willingness to facilitate those kinds of visas as long as you can meet all of the requirements that are within that category.
Mm-hmm. Now, to wrap up kind of this business investment stuff, we talked about treaties and we talked about the investment base, but Canada has a treaty with the U.S. called the E-Visa Treaty, where if you're doing a lot of business in the U.S., it's the E1 or E2 is if you're investing, starting a business. Normally, these kind of treaties are reciprocal, where an American go to that country too to do the same thing. But Canada hasn't set that up, it seems, and as you said, there's no investment program, so that's something to be mindful for if deciding to go to Canada, thinking to use that. It's not as easy as it is. I don't know, like European countries have that, Netherlands has that, a lot of the EU countries do reciprocate that. For example, U.S. just signed the e-visa treaty last year with New Zealand, but New Zealand hasn't created its own laws to allow U.S. citizens to go and invest there. So until New Zealand does that, the treaty doesn't go into full effect for New Zealand citizens to come to the U.S. and start businesses. So I guess Canada.
It's only one way.
Yeah, Canada, right? I'm not even sure they're not even allowed one way yet until New Zealand does it, which is why it's kind of shocking that Canada is doing it like that. But it's just Canada has a special relationship with the U.S., so there's all sorts of things that. You guys don't need visas to come here. You go to the border and get a lot of stuff. So
exactly, and I think because we do have all of those visas that are available under the NAFTA or the USMCA, so I think that under that there are a certain number of provisions that would allow like that intra-company. There are other.
It gives
types
the flexibility.
If you're a company, you're doing. Yeah. And then, even if you're a company in the U.S. and you need to send an employee into Canada who hasn't been with you for a year, but we can demonstrate that employee has, is going to provide significant benefit into the Canadian economy. Like he's going to come over and he's going to bring and train the Canadian workforce within that organization. So that U.S. entity, it's under the C10 category. We can process those kinds of visas. If a company in the U.S. has sold products to a company in Canada and they need to service those products, let's say, a furnace or, some sort of large machinery, there's visas that allow us just right at the border or even, in other ways to be able to process those employees to go over and repair that U.S. sold machinery. So we do have other types of visas that I don't know that the U.S. has with other countries. So we're fortunate in that sense.
Now, you mentioned the easiness of coming to work there for a limited time. I remember when we talked, you said like a wedding singer could potentially just come for a day and come back. The U.S. is strict. If you're coming for work, it's not happening until you get an O, which has paperwork and it's expensive. Canada has that flexibility to allow people to just come in for short periods for work.
Well, so the wedding singer is the only one that, I meant to say that the other day when we were on the phone. The wedding singer is the only one that has that special sort of, hey, I've been asked, this is a private wedding. Yeah. But for any other entertainer or performer, they would have to go through that similar process that you guys have in the U.S., that O or P type, visa for the artist or the actor or the producer. They would have to prove their credentials, I should say, over the years and why. Yeah. So it's just that wedding singer is just it's like a nuance, I would say, that they allow for that one night with the contract, of course.
And now I'm getting to nitty gritty stuff that I deal with here. Is does Canada have dual intent issues where if someone comes on a tourist visa and then decides to stay, they'll say, "Oh, you came with the immigrant intent, and that's misrepresentation." Is that something that comes up, or is the
Yep.
worry there?
Oh, it is, and oftentimes when I hear about all of the issues surrounding illegal immigration, and, one of the biggest areas, I think in the US too, but certainly in Canada, is people who have come legally. So they've entered on a visa, and they're still in Canada because they overstayed that visa. And
Hmm.
so when you have that overstay, and if you're caught, you have to depart within 30 days. Otherwise, it's called a departure order. If you don't, if you're caught, right? There's lots of people who are in Canada illegally, have not been caught, and so they're there. But if they get caught by IRCC or CBSA, they're asked to leave. They have to leave within 30 days. If they don't leave within 30 days, then they can be issued a deportation order. And that person trying to get back in Canada would need what's called an ARC, so it's an authorization to return to Canada. And it's discretionary, right? So, I mean,
Yeah.
if you can say, hey, I didn't know I overstayed. I thought I was already applying, because unfortunately we do have a lot of immigration consultants who are not attorneys, and we have
Hmm.
a lot of people who try to do it on their own. And so there's a lot, I don't want to say that it's always in the control of the person, or sometimes they think they've trusted somebody to help them out. And so some of those overstays can be overcome. Now, if we're talking about misrepresentation, so if somebody's lied, they've provided false information on documents, that's where there would be that 5-year bar where they're going to say, hey, you know what, please don't come back for 5 years. And they can even go so far as to take away status. So they can take away a permanent residency. They can take away Canadian citizenship.
Hmm.
They can issue the deportation. So the misrepresentation has a minimum 5-year bar. And the overstay, they have to leave, but it's, if they try to come back into Canada, it's discretionary and on a case-by-case basis.
See, so Canada doesn't give them a shot at a removal or deportation proceedings beforehand. It's just if they get caught, they got to go, kind of thing.
Right. And I mean, you do have those proceedings, but it's that's sort of the procedure, right? So I'm walking down the street. I was here, 3 months longer than I was supposed to. They catch me. They say, okay, you've got to leave. And then if I don't leave, and then it's another 6 months, and they say, hey, wait, you were issued that departure order how many months ago? Now it's going to become a deportation order. Now you can go through and say, hey, here are the reasons why I'm still here. This is the application I'm working on. I thought my application was pending. So I think we talked about the other day, we have that labor market impact assessment
Hmm.
process in Canada that sort of like your labor certification. There has been an unexpected delay. So they used to be 8 weeks, let's say, maximum processing time. Now the processing is at 25 weeks.
Wow.
So you've got people who are in Canada awaiting, work permits, but they can't apply for their work permit until they get the LMIA. So it's caused this domino effect. And so somebody's going to have to explain, hey, look, I was here, but I was waiting for this portion of the application to be complete so that I could renew my work permit.
Interesting. So,
So it's tricky. Yeah.
two questions come up is if someone enters without a visa or without here's inspection, they call it, just walks in and then applies for status, was unlawful entry become a problem, or is that waived? Or in this case, whether if they overstayed a visa, could they still get a work visa, or do they have to leave and go to the embassy, come back in as you would in the U.S.?
Yeah, so you can try that certainly. And so there are people who come in unlawfully and then try and overcome their status issue, or overcome the overstay, or overcome the misrepresentation. And so again, depending on what your submissions are going to be, whether it's based on a humanitarian or compassionate grounds, or whether it's I have to work. And so it's really on a case by case basis. It's not really black and white, but you could come in, then apply elsewhere, go to that embassy, get that visa, and then be able to re-enter if you can demonstrate that you qualify to have or that you did endure some hardship, so therefore it should be overlooked.
Interesting. So, if someone did enter unlawfully and then married a Canadian citizen, could they stay and adjust status and become a green card holder there, or a
Within
lawful?
Canada.
I'm
Yes,
sorry.
they can, but they
Oh
can,
wow.
but they'd have to prove that the marriage was a legitimate marriage, and so that it was bona fide, and that the marriage didn't happen just for the sake of obtaining the status. So the relationship, and they'll dig. I mean, they want to know,
Yeah.
and I think it's the same way in the U.S. Okay, so I want details of this relationship. Have you met their family? They met your family.
Yeah.
You know, we want dates of how many times you guys spoke, how many times did you guys see each other, how did you meet, was anybody coerced, those types of things.
But they'll still allow people to adjust status and get the green card if they enter unlawfully. Because U.S. To be able to adjust status, you have to have a lawful admission of some type or advanced parole or parole. But there, Canada is not as strict as how you enter it, as long as the relationship's okay.
Right.
Oh wow, that's
As
insane.
long as the
Yeah.
relationship's okay, and if you can prove that, you'd have to explain it still, though. You'd still have to overcome that unlawful entry, right? So I came in, so for example, if somebody says I came in on a visitor visa and I thought it was a work visa,
Mm-hmm.
you would be, you should know how many people think they've got one visa and they have another.
Yeah.
Or, I came in, let's say a U.S. citizen, I came in, I don't need a visa to come into Canada. But I stayed longer than I was supposed to. Then I met somebody and I stayed here. I didn't know I had to leave within the 6 months, right? So
Mm-hmm.
it just depends on the source country where they're coming from. And we have, so many people no longer need visas to come into Canada, right? So many of the European, the EU countries. So they get their electronic travel authorization, their ETA. They come into Canada, and so they didn't really have to go through a whole application process to come here. But they're here. Now, if you've got somebody that was smuggled into Canada, right?
Mm-hmm.
So you've got that type of situation. Again, if you can prove that you thought you were lawfully entering, and you then adjust by marriage, that's one thing. If you knew you were being smuggled in and you paid somebody to bring you in and you knew it wasn't a legitimate visa, then it's going to really depend on how IRCC looks at that case.
So your system is very subjective too, like ours. It's up to the officer, whoever you get, kind
Yeah.
of thing.
It's up to the officer, it's up to the reviewing officer,
Mm-hmm.
or up to the judge. If it gets to that level, to say that it's black and white, it really is not,
Now
which is good and bad.
yeah. You mentioned the ETA. So is that like our visa waiver program where like,
Yeah.
so they actually just instituted work, because I've had a lawful permanent resident U.S. clients who would typically just go to Canada, show up at the airport, it was good. But now it's been probably a year and a half where they have to go and register online before and get some sort of approval before they're allowed to try to enter Canada. So that was interesting that came up. People have green card holding clients want to visit Canada. It's not as easy as it used to be.
No, it's
Yeah.
not.
Do you have a formal waiver process where when people have these blemishes on their record to ask? We have a 601 waiver and stuff. Is there a formal system, or is it more just like a motion or a letter that you write explaining the hardship?
No, we have what's called a TRP, so it's a temporary resident permit, and that's typically used in almost any kind of inadmissibility situation, right? So whether it's criminal inadmissibility, any kind of misrepresentation at the border, overstay, previous criminality from your home country, and those TRPs, depending on where they're submitted. So if they're submitted at a consulate, or if they're submitted, at the service center or at the border, the processing time is what varies. So there's not any consistency or rhyme or reason, to say, oh, it takes 8 months. It could take same-day processing at the border. It could take 12 months processing somewhere else. But that there is a specific form that's used, but then you have to put together your whole submission explaining what occurred, right? So to your point, why you entered unlawfully or why you overstayed unlawfully. And so then, and that's what we do, right? As the attorneys, is try and assist in terms of what those hardship submissions and explaining the situation so that's the one way. If somebody had something that occurred more than 5 years ago, we can then apply for what's called a criminal rehabilitation.
Mm-hmm.
You cannot apply for those at the border. Those are at the embassy or at the service center, in Ottawa. And so that process, once you've got that criminal rehabilitation, you don't have to reapply every year or, after the expiry of the TRP. So as long as you've kept your record clean, you haven't had any issues after that rehabilitation is permanent.
I'm glad you brought this 5-year thing up because any immigration lawyers listening here probably had at least one phone call from a person, U.S. citizen even visiting Canada, and they were prevented from going there because they had a DUI. What is the situation with Canadians and DUIs and immigration? Could you break that one down?
Yeah, we don't like them, so that's the first thing. But in October, this past October, we changed legislation in Canada that allowed or legalized cannabis, marijuana for recreational use. With the legalization, we had to amend and change some of our legislation that allowed for that to happen. And in so doing, we further criminalized DUIs, meaning DUIs were then considered to be more serious criminality than they were before. Even before that change in the law, Canada tended to look at DUIs more seriously than the United States did. So if you've had, even if it's just one previous DUI, and the DUI was 10 years ago, you can be found inadmissible into Canada. And you would need what I'm calling the TRP to be able to enter in straight away. Or if it's been more than 5 years since, everything, so your probation, your sentencing, your fines, all of that has been done, then you would be eligible to apply for that criminal rehabilitation to then enter Canada, legally.
What if it's only been like a year that you had the DUI? Is that just going to be impossible?
It's not going to be impossible. So if let's say it was last year and your company needs you to go to a conference in Toronto, and I have that often, right, where we'll say, okay, we will prepare an entire package for you, explain that this happened to you. We'll get character and reference letters from your coworkers, from your friends, from your family, from your church, from your mosque, from, various places where we'll say, hey, look, this guy really didn't mean to do what it was that he did. And, please excuse this behavior. If you've gone to AA, we can submit, proof of that. And so if we're able to compile a compelling argument as to the fact that this person is not going to be any threat to Canada or to Canadians, and isn't going to, for example, get it behind their car and drink and drive, or if it was an assault case, that they're not going to, be violent. So depending on the situation, as long as we can prove that they are, rehabilitated in the sense that there's no immediate or imminent threat, and if we can prove that there is a need, so they need to come into Canada for their work purposes, then we can apply for what we call the TRP right at the border for them.
Okay. And what about with the changes in the marijuana laws there? If someone had a marijuana charge in the U.S. and wanted to go there, it's going to pop up in the system that this person has criminal history. Is that something that would prevent them if they just explained it? I'm sure it's all new and they're just starting to deal with this stuff. But how was U.S. immigration work on that aspect?
Yeah, I think it's going to be similar. I think they're going to look at it like it's a DUI, meaning they're going to say, at the time, this was a criminal offense.
Oh, okay.
So even if they say, yes, guess what, it's legal right now, but 10 years ago, 5 years ago, that was an offense that you committed, and you're still, now that there isn't any direction, so don't quote me here, there's not a policy that's come out that said, but I imagine that based on what I'm hearing, that is the way that they will treat those kinds of previous offenses.
Yeah, because it makes sense. They knew it was against the law when they did it, so it shows the psychology of willing to break the laws as they're written, regardless of what's the law now.
That mens rea, exactly. That intent to commit the crime was there, and that's what they're looking for.
Interesting. And kind of jumping ideas again, what is the timeline on marriage cases? So is there a difference between being married to a Canadian citizen and a lawful permanent resident Canadian? Do they have separate paths and timelines, or are they the same? And what are the estimates on time right now?
They're quite similar, so as long as you've been a permanent resident for, at least a year, you couldn't have gotten it today and then, want to sponsor someone tomorrow. That's going to take a bit longer. But if you've been a PR for a year, 2 years, you're going to be in the same stream. As long as you can prove that you're able to, financially sponsor that spouse to come over, that you've got the roots and that you're established where you're at in Canada, there's not really a difference in those two streams. Processing time, everything in Canada is backlogged right now. Every agency, every processing center, it's just, our resources are just taxed right now. So you're looking at a minimum of 12 to 14 months processing for the spousal. That's from, completion. Now, typically from the time that you would approve, within 3 months, you should get 3 to 4 months, you should get that initial approval. that says, yes, you can sponsor. You are qualified to sponsor.
Mm-hmm.
Same timing, once you get that, yes, you're okay to sponsor, you're going to get an ability to have that spouse come in and get what we call an open work permit. So where we're going to say, hey, this person can come in and they can apply to work or they can work in Canada wherever they want by virtue of being sponsored. And then the background checks, the criminality checks, the medical exams, all the rest of that is what comprises that latter half of that, the bulk of that time to finish the processing.
I mean, those are still good with the timelines we have. Those are it's like a good dream.
I know.
Now, because we separate lawful permanent residents, they could essentially file immediately for like a foreign spouse or child or something like that, but it's going to take at least 2 years right now for them. But immediate relatives, marriage cases, there's no line, but the bureaucracy delays probably end up being 12 to 14 months if the foreign spouse is overseas as opposed to being in the U.S. And if in the U.S., it just varies upon which field office you're going to be dealing with. Some like to faster than the other ones. Another, Canadian kind of issue is, what is the naturalization process there? How long does it take? How many years of lawful permanent resident status do you need to become a citizen there?
Yeah, I think it's similar to the U.S. In the sense that it's the
5 years.
what we call 1095. Yeah, the 5 years. So once you've got that 5 years under your belt, like you're able to apply for Canadian citizenship.
And do they have any extra rules, like with regard to being able to speak English, or like do you have to do extra stuff, or is it really just because here we have,
You do have to, take the exam. You have to take the citizenship exam. I think it's similar to yours in the sense that, the bulk of the questions and, based on a lot on, I often say, even though I was born and raised in Canada, I don't know if I'd be able to pass the test, right? So there's so many history questions and, Canadian, and I say, oh boy, I'm not sure if I'd be able to pass it, but yeah, so not necessarily, because you have to do the English test to get the permanent residency, right? So that's a requirement. There's not necessarily an English test, but the exam, the citizenship exam, is taken in English or in French.
Interesting. Okay. And then now we talked about DUI stuff. Now we had talked for something interesting last time, is that your embassies aren't as strict as we are, because in the U.S. the embassy goes at it all over again, even though they're many times they're not supposed to. The consular officer will like review the case in its entirety and give their opinion. But it seems like Canadian embassies are more lenient and they have more procedural side to it. Is that correct?
Yeah, like typically if you've gotten approval at the service center in Vegreville, Alberta, or online, you're not going to see an embassy reversing it. What you're going to do is you're going to see them verifying that what you've submitted in your overall package is in fact true. Now, if something comes up in the interview that they say, oh, this is not consistent with what you said, you'll see a reversal.
Yeah.
But if the interview goes well, if everything is consistent, if the information that's presented is genuine, well documented, truthful, can be verified, you're going to see consistency with the decisions.
And how difficult is it communicating with the embassies and the service centers?
Yeah, that's not great. So, locally, they're amazing, right? Officers are great to deal with. When you're trying to reach people sort of at the embassies or up at the service center, very, very difficult. There is a mechanism by which if you want to do a follow-up on a case, you can submit that. You'll be told that within 10 days you'll hear something. Generally, that's the case. But in terms of being able to like pick up the phone and say, hey, what's going on here? You don't really have that.
Mm-hmm. What about briefly talk about humanitarian type cases? You guys have the equivalent of the being a victim of a crime or sex trafficking victim. I'm sure you have those in asylum, obviously. Do you also have a thing called TPS, temporary protective status, where Canada will declare people from Haiti all of a sudden could stay here because the earthquake happened? Are there any national declarations like that, or is that the U.S. specific kind of thing?
Yeah, the U.S. seems to be more systematic, right? So there's an event somewhere, you're going to see that TPS issued for Haiti for to your point. We don't have it that regulated, but for example, with the civil war that was happening in Syria, we opened up right away and said, okay, we're going to take 25,000 refugees because we understand that this is a world crisis. This is our responsibility. We're going to step up. And, it was really interesting to see the number of Canadians who opened their homes, opened their businesses and said, yes, we're going to help out where we can.
Hmm.
but we don't have that same program like the TPS, the way that you guys do. We do have the visas if somebody has been a victim of a crime, victim of human trafficking, human smuggling, anything like that. Yes, we do have visas that allow them to stay and to work and to eventually become PRs in Canada. But we don't have that same sort of systematic that if there's an earthquake you can expect, or that so we don't have it exactly the same. But we are quite humanitarian in that
Hmm.
sense.
Now, and I know you don't practice in removal proceedings or deportation hearings, but in the U.S., the vast numbers of people going through the system are so high that a big chunk of immigration lawyers just do removal and deportation and stuff. Is the need for immigration court-based lawyers that high in Canada? How is the
It is.
system there?
It is. Yeah, and I find I've got a couple of people, one in Windsor and one in Toronto, who I refer all of my refugee work to, because it really is a specialized practice. I mean, just like I sort of focus on the things we discussed today, I
Hmm.
find that if you're in the area of handling refugee cases, that's specifically what they do. And you find that a lot, that because there is such a big need for it, that their whole practice will be comprised of that kind of work.
Very interesting. So, what are the main focuses that you like to work on? The types of cases.
Yeah, pretty much everything that we talked about today, the spousal sponsorships, the TRPs and the criminal rehabilitations, the skilled workers with the arranged employment. So those are really the top five, I would say, cases that I have on my desk right now, and that I tend to work on. The TN visas often, weekly.
Hmm.
The
You're on
the
the border, right?
intercompany
You're in
transfers.
Toronto on the border.
Yeah, because I'm right on the border between Windsor and Detroit. Yeah,
Hmm.
so I'm right here. So anything that we can file at the border, definitely like to do that. So all those NAFTA visas, the intercompany transfers are my favorite. So I know that sounds, I'm a bit of a nerd in that
The
sense,
same here.
but I do like that kind of work. So and I find much success with it as well. So it's good.
Good stuff. And one last question is, we mentioned it briefly. You talked about the immigration consultant situation. I see so many advertisements and people on LinkedIn adding me, and people emailing me that are immigration consultants from Canada. What is that? Is it because we have notarios and consultants here in U.S., and it's it's a love hate or mostly hate relationship with immigration towards their practice,
Yeah,
because they can miss a lot of stuff. It's a very dangerous thing to mess dabble in, or not have full lawyer type responsibility on. It seems like it's very dominant in Canada, though. Is it kind of crowding out the immigration lawyer
it
market?
is. It is. It really is. And they changed things where they said, okay, we're seeing so much of this that we're going to have to legalize it. So essentially, they're more than a paralegal, but not quite a lawyer. And they've got to go to school to get the accreditation to show that they've got. And some of them really are more knowledgeable than some lawyers,
Hmm.
honestly. But they're still limited in what they can do, and they don't have the same code of ethics that we have. And so there are some differences, and so I think it's just a matter of having the right person who has the understanding of the law and who applies it the right way. So it is different than in the U.S. in the sense that because they have the program where they have to go to school, they have to get accredited, they have to keep up with their continuing education credentials. So it is regulated, and I like that part about it. And I think since they've regulated it, I'm seeing a lot less and less issues
Hmm.
where not just anybody is making attempts to fill out applications for people.
I'm glad you brought the point, because especially in California, Southern California, it's a constant battle between notarios doing damaging cases, filing cases they shouldn't. But if it's somewhat regulated, where there's a balance where they do educational stuff, they have to keep up certain requirements, at least the standards go up higher. But at the same time, the people who are just filing asylum claims just to do it and make money, and then fooling the client, those people are always going to be there. But yeah, if there's a system to educate them, and so they're more familiar with the nuances, that's not just a form. There's a million and one disastrous things that can happen. That'd be good if they had the
Right.
patience to study this stuff. But
Correct. Yeah, exactly. Exactly.
well, that's about it today. Is there anything else you'd like to talk or mention about just Canadian immigration?
No, you've been great. I mean, you covered everything that I would have wanted to say. So thank you.
I really like to set up a follow up, tutorials kind of stuff, where we'll probably pick up on specific aspects of this and go into more detail in the future.
That's
But
great.
other than that, do you have any social media handles that the people could contact you at, or what's the best way to contact you?
My website is really one of the best ways, just laurietannous.com. You can find me there, and you can contact me right through my website. So that's and I do have Twitter and Instagram as well, but my website is probably the most interactive and the best way to reach me.
Great. I'll put that information in the show notes, especially Twitter and stuff like that, so people could follow you. And that's about it. Thank you so much for
Awesome.
having this discussion. It was very helpful.
Thank you, John. I appreciate it. Take
You're
care.
welcome, Laura. You too. Bye bye.
Okay, bye-bye.